I sat down for an exclusive interview with Chet Kanojia, the founder and CEO of Aereo, the broadcast TV streaming service which filed for bankruptcy last week after the Supreme Court judged its service violated copyright laws. Well, in an exclusive interview, Kanojia told me the true underlying reason he thinks the legal system dismissed his company.
Hindsight's 20/20, but I just think that there was novelty is a big issue. It seems like in the legal system, if you're new and you're different, you must be scary. At least that's an outsider's perspective. Obviously, I have no idea what goes inside the Supreme Court or any court for that matter. And you know, novelty scares people. At the end of the day, I think if you take a step back and say, what did this company really do? It was opening up a marketplace using complete, you know, and multiple federal courts had found that we were absolutely right. So yeah, it felt like it was a incorrect decision from our perspective. And to the extent that there was discomfort, at least from my perspective, and I think the dissent sort of said this, to the extent there is discomfort in this prevailing, Congress is perfectly capable of fixing these things. And in fact, the incumbents have a lot more control over the congressional process. They have a lot more lobbyists. They spend a lot more money. They've been around the block a few more times. And let's not forget, they've done this multitudes of times. They've changed laws to accommodate for new technology. They should. And I think, you know, it's probably appropriate to be very clear. You know, that's obviously Aereo has a perspective on this because we had an axe to grind. I understand that. And the court probably wisely, incorrectly, however you look at it, took their view, and it is what it is. The Aereo technology was not intended for any old content. It was only very specifically to broadcast TV, which was free to air. So the argument we used, obviously that didn't succeed, was you know, consumer has the right to an antenna. It doesn't really matter whether the antenna is located on my roof or on my handheld, or it's a central antenna that I'm leasing. Or the specific technological implementation is irrelevant. That was our argument, and the court said, well, it's actually, how you do it doesn't really matter. If it looks like cable TV to a company, we must treat you as such.
Right, and you must pay for that content.
Well, that's actually where it's even harder to understand the law as it's sort of the compulsory license, which is what under copyright law you're required to pay. We were happy to pay, and we actually had filed all our filings and things like that. The challenge was the market has evolved in the early 90s and mid-90s to just from a copyright-based payment to a retransmission payment. Which isn't copyright law, by the way, and we were sued under copyright law. So there was this mishmash of competing regimes that sort of came together, and you know, I think it's pretty obvious that the day we started, we built everything to comply to the T with the law as it existed back then. And if there was a mechanism in which there was a framework that said this is how an online provider is supposed to operate, we would have done that. It didn't exist.
It didn't exist.
And so we had to create that argument, that question, that opening, and you know, we took the approach we took because we thought it made the most sense to drive the conversation forward.
You know, you've been immersed in this world for 3 years, right? Should content be free? Should it actually just be free?
I believe in markets. I firmly do. And I think if a content provider wants to charge $100 a month for that, they have every right to charge $100 a month. If they want to provide it for free, they have every right to provide it for free. If you are a broadcaster that's broadcasting free to air to a consumer with an antenna, you can't take both sides of the argument. That's really the. If those companies weren't broadcast, we didn't do this with HBO or Turner or any of those, right? So it was very specifically free to air broadcast television. It had nothing to do with, you know. So if they elected, they said, we're not a free-to-air broadcaster, we would like you to pay $1 million an hour for our content, great. If the market bears it, I think that they have every right to be able to do that.